Hey everyone, welcome back. I am so glad to see and or be heard by everybody out there today. Um, Today I have with me Diana Romanov. She's a San Francisco family law attorney. She is licensed in both California and Germany and is a certified family law specialist. She is fluent in English, Russian, and German and provides counsel, representation, and mediation across cultural lines, which is one of the things that one of the reasons I really wanted to talk to Diana about was this cross-cultural and also international divorce. Before launching her own boutique firm, Diana served as a prosecutor at the Regional Superior Court of Berlin and practiced at major international firms. Um, all very exciting and I think really relevant to a lot of our listeners. So hi, welcome.
Thank you. Thank you for having me.
I'm happy to have you. So let's just first talk about like how did your international background um, shape your approach to family law? This is not, you're not like someone who was trained in California and lived in California and practiced family law in California. You've had this broad experience of international experience. How did that shape how you approach family law now?
First of all, I immigrated to Israel when I was 14 and then immigrated to Germany when I was 15 and then immigrated to America when I was 30. So I
Oh,
had experience being an immigrant in three different countries. And when people who not only are facing to be in a different country, but also facing the most difficult thing that life can offer, divorce, immigration, the type of compassion I have for them
yeah.
is extraordinary because I have experienced that. I know what it's like not to understand not only the language but the law.
Yeah,
And
right.
it's complicated. I don't know why it has to be so complicated, but just feeling getting married in Las Vegas is super easy.
That's right. Yep.
10 minutes in and out, a couple
Yeah.
$100, that's it. Getting divorced, it's a different situation. You have to disclose all your assets. You have to fill out certain forms. And the clients who have tried to not involve lawyers and hired paralegals, they have paid later bigger price. I had clients coming back who used the paralegal, and the paralegal didn't include spousal support waiver language the way it's supposed to be included, not just the waiver, but modification
Right.
or
Hmm.
termination
Hmm.
of jurisdiction of the court or things like that. To answer your question, I have more
Yeah.
compassion
Yeah,
to
sure.
people who are going through difficult time. And if they don't speak English very well and have different types of issues, dyslexia, ADHD, had it all.
Yeah.
So I'm
Right.
like, don't
Absolutely.
worry, just speak
Yeah.
slowly and so will I.
Right, exactly. And I think what you're saying about laws differing is, I mean, it's so I as a coach, right? I work with women all in all states, globally, really, but mostly in the US and Canada, right? Well, I can't hold all of the different, the divorce law differs so broadly from state to state that I can give legal information. We can like Google stuff together and I can say, oh, okay, so this is what it means in your state, right? But I cannot imagine what that is like internationally. And and is there even agreement on jurisdiction, right? If you have if you were married in, let's say in Germany, and you emigrate to the US, let's say, one spouse wants to go back to Germany, like who has jurisdiction over the divorce?
Just remembered the joke, but I'm not going to say it because I cannot say jokes really well. But it's the bottom line is, what jurisdiction do you want? So when client
Ah,
calls me,
yes. Oh, that's
it's like
interesting.
close the windows and the shades. It's like, what what jurisdiction do you want? And so what I
Uh-huh.
do ask my clients to do is to, first of all, in California, even if they're not resident, meaning they're not yet 6 months living here,
Right.
but they want California to be the jurisdiction, we can file for legal separation if the money is here and if they intend to live here. Then the issue becomes if the other side is going to travel to California, so we can serve them the paperwork to get jurisdiction over the other side. So it's not about just the court, whether the court has the jurisdiction. Does the court has jurisdiction over everyone involved?
Right. Right. Because if one party's not here, they can't even be served.
Correct. So I had an international case where the other side was in Germany and we served properly through Hague,
Okay.
but the court only is allowed without minimum contact of the other side to California to terminate marital status, not divide all assets.
Oh.
So, which means proper service, no jurisdiction over divorce, only legal status. The way we circumvented this, we asked the other side to file a response to the petition, and then we filed an RFO and asked the judge to divide assets because the judge wanted to speak to the other side. So it's where the money is, where is better law. For example, in some states, I believe it's Massachusetts, but I'm not practicing there. So when I had a client and we talked to an attorney there, they're like, oh, there's no spousal support usually,
Right.
especially in a short-term marriage. In California, that's standard to have spousal support, half of the
Mhm.
length of the marriage,
Mhm.
up to 35% of net disposable income. From the other side, minus 50% of the spouse who is asking for support. There is a formula,
There's a
ex-spouse
formula.
formula.
Right.
Exactly. There is a
Mhm.
formula.
Right.
It's not, it's
Yeah.
usually it's always the case. The spousal support is granted. Need-based attorney's fees is granted. In some states, maybe that's not the case. In some countries, maybe that's not the case.
Yeah. Yeah. And it's one thing to say, well, which is more beneficial to me? But if your soon to be ex, if it's not beneficial to them, they're going to fight that. So how do you get both parties? How do you even get agreement on jurisdiction? If one person's like, well, it doesn't work for me as well as it might work for you.
Well, we don't get an agreement on jurisdiction unless we have leverage.
Hmm.
So first, we'll determine if the court has jurisdiction over the other side. Can we serve the other side in California? Can we establish jurisdiction to begin with? If that's the case, then we don't need to reach an agreement about jurisdiction. Then we just do what we got to do to get the jurisdiction we want. And then we can reach an agreement about the split instead of jurisdiction. If I'm on the other side and I would like to reach an agreement and I know the law is less favorable to my client, what I have done is when a client came to my office in one case, he said, my wife filed and I know she's about to serve me in LA, and he came to my San Francisco office. I said, well, if you don't want to if you don't want to travel to LA, then you need to be not only the one filing first, but you also have to serve her first. It's not about who filed first, who served first. And so we served her, we filed and served her the same day when as he came to my office.
Hmm.
So she had to dismiss her petition.
Mm. I
Agreements are
see.
good if it's possible to
Yeah.
reach those agreements, but sometimes even reaching out to have an agreement could
Tips.
lead to,
Yeah.
yeah, could lead to unwanted service.
Right, because it kind of it tips your hand, right? It sort of it
Exactly,
shows
exactly.
yeah, right. Yeah. Okay, I get that. Yeah, it's all very complicated. I think, like you said, I wish we could all agree on divorce law, at least in our country, let alone internationally. But
Then
Jesus, I
we
mean,
would be out of job.
well, well, maybe not. I mean, there's still
Yeah.
anyway. But yeah, it would be nice if the laws were at least consistent so that we could so that people knew what to expect, right?
Yeah.
Half of my job is helping women understand what it is, what to expect once it happens, right? People don't necessarily always want to, I mean, even if they want to get divorced, they still need to know what is my life going to look like? Am I, what are my children going to be safe? Am I going to have enough money to live? All of these things that they need to know in advance. And with all of these laws that it's always like, well, it depends. You
Depends.
know.
Favorite answer of a lawyer.
Yeah,
Yeah.
exactly. It depends. Exactly. Yeah. So all right. So what are you seeing in um even cross-cultural divorce, right? We were talking about like different divorcing in different countries, but even culturally, even if you're in the same country or the same state, are you do you see things where cultural differences are impacting the legal process?
Yes. I
Okay.
can't forget this case where a woman came to my office and then she said, I have been married for over 20 years and I haven't seen my husband's accounts. I don't know how much money we have.
Hmm.
And it was a cultural thing where in their culture it's not typical to for man it was typical for man to earn the money
Hmm.
and be in charge
And control
of
it. Hmm. Of
financial aspects. Right now we would say
course.
coercive control and financial abuse and all of that, but in their culture it's completely normal. And it's not just one client, it was just the first client where I was like,
Oh yeah.
what,
Oh
for
yeah. I mean,
20 years? And then many more came through with the same standards of
mhm.
cultural acceptable norm.
Yeah.
And
Yes.
not far long ago in my culture, that was also the thing.
Sure. I mean, listen, I think there are a lot of cultures within the US, that have these in religious cultures or, more patriarchal cultures. That's the deal. We have the rise now of the trad wife, right? And then the trad girlfriend. These are people who are, willingly giving over all of their financial power or agency to men, and it's glorified. It's something that's considered a status symbol.
That's right.
Very
So
dangerous. Yeah.
that's one thing I noticed. Another in my culture, Ukraine, ex-Soviet Union, let's put it that way,
Yeah.
because when I left, it was still sort of Soviet Union.
Yep.
And that, and still now, women get sole custody of a child.
Yeah.
Still completely by default the norm. And
Yeah.
so when a woman calls me and she's, what? What are you talking about 50-50? I have been raising our children. I have been bringing them to the doctors and to school. He has been making
Yeah.
money, sure, but I have been the sole caregiver. And the next thing you know, he has his mother coming from somewhere
Yeah.
out of the woods and now equally takes care of the children and while he's working, so he has to pay less in child support. And then trying to convince the California judge that it's not okay is really tough.
It is very tough. How do you handle that? Because I mean, that's beyond common. I mean, if you have been a stay-at-home mom, um, almost, a huge portion of my clients and listeners are in this situation where they have been a stay-at-home parent, or they are a working parent and still doing all of the child labor, all of the, right, domestic labor, and are married to men who maybe don't participate as much in raising of the children, and now all of a sudden want 50-50 because they don't want to pay the child support, or they don't want to be seen as a deadbeat dad, right? So now all of a sudden they want 50-50. And legally, the courts are favoring that more and more. How do you represent a woman in court who is in that position? And what do you advise her?
Before we even get to court, I get to the bottom of it.
Hmm.
I find out what is the motivating factor for dad
Hmm.
to be 50% dad. And if it turns out to be child support, then, and my client tells me, you know what, I rather have 90% with the children and he pays me less.
Yes.
We put on paper 50-50 if it makes him look good.
Yep.
If he has, narcissistic tendencies to look certain way, then we just put it on paper that the parents share reasonable timeshare, equal timeshare, and then don't specify. Or we say 50-50, but we agree on the side in a different agreement that he pays X amount in child support that is less.
Hmm.
And and sometimes that's what it takes.
Yep.
Sometimes
100%.
that's exactly what the agreement tends to result in a really, really good outcome.
Hmm.
And sometimes women come and they say, I have 100% of the time our child and he doesn't pay anything.
Hmm.
And then what happens in 99% of the cases, if they start asking for child support, if then he starts to ask for visitation because then he has less to pay.
Hmm.
So then we assess there. So my job is to get to the bottom of what really, really, really is the desirable outcome
Right.
and then compromise.
Hmm.
Because in this type of situation, I ask her, do you really want 50-50? Because that's what will happen in a year.
Right. Right.
If
Yeah.
not, then cover child support yourself because then he will come after like equal timeshare.
Right. Exactly. I'll often advise my clients similarly. I'll say, listen, if I love, I do exactly what you say in terms of right, if he just wants it on paper, because he doesn't want to look like a deadbeat, but you want to make a side deal on whatever, like great. Like let's just do that. If it just needs to be 50-50 on paper, but he's not going to show up for it, then or he doesn't want to pay for it, fine. Let's right. The other thing I say is if a person who has not shown much interest in parenting for the life of the child beforehand is suddenly like has to be dad of the year and definitely has is fighting tooth and nail for 50-50, then I say let him do it. If you know that he's going to slowly fall off that cliff, right?
That's exactly.
Agree to it, knowing that within a year, he's not going to be exercising his parenting time. And then, if you want to document a year's worth of not showing up for parenting time, and if you want to file for support, for increased support based on 90-10 versus 50-50, if the money is like, if it's actually a lot of money, because most times it's really not, it might be a couple $100, right? Depending on the
Yeah,
income,
exactly.
then you can file with that documentation. But if we know he's just going to kind of fade out, then let it happen, right? It's not worth the fight.
Exactly.
Yeah.
And most of the time he doesn't show up. And I had a case where we had in judgment paperwork 50-50, but for 5 years he hasn't been showing up. And now he's asking to enforce the judgment. The judge is saying, of course not.
Of course not.
No,
Yeah,
of course
right.
not.
Right. We have
Yes.
proof that you actually don't care very much,
And
right?
I wouldn't even suggest to that client after 1 year to file for modification because then he will be back on track and
Mhm.
trying to look good,
Sure. Exactly.
not just
Exactly.
document 5 years of no show.
Yeah, sure. And if like, I mean, I think I'm a firm believer that if the money actually matters, like if you are in financial hardship, because you have to support your children 100% of the time with no support, then we have to do something to equalize that. But sometimes it's going to cost you more to hire the attorney, to file the motions, all of the things. Um,
Speaking of which, I when a client calls me and says my ex doesn't pay child support, and I notice money is a problem, which is usually the case unless it's a super high asset case, then I suggest to contact child support services
that's right. That's right.
because they do it for free. They don't,
They
you
do it
know,
for free. They take it off your plate. It has absolutely nothing to do. You don't have to pay for it. You don't have to. I mean, I agree with you 100%. If they are failing to pay what is in the agreement, then we have to, yeah, do it through child support services because that's their job.
and if someone contacts me and says child support services contacted me, or can you defend me in a child support case, if someone is trying to evade or avoid paying child support, I
No,
I don't take these cases. It
no.
just feels to be on the wrong side of. There are some cases where the other side makes millions of dollars and goes after my client because of some legal concept. But other than that, those are really the child support services type of cases. I
Yeah.
also had a case where I was representing a woman who had two kids and he had his W-2 job, didn't pay child support. And then what he did, he opened different businesses
Hmm.
that were losing money to
Yep.
offset his W-2 income against the businesses.
Yep.
So
Yep. I
it
see it
ended up
all the
being
time. Yep.
being a trial, and thankfully judge was in child support services made that same argument that we made, is that his financial decision should not, the children should not pay the price of his poor financial decisions or smart financial decisions, so he avoids paying taxes but not child support. And tax returns are presumed to be correct unless someone owns the business,
Right.
so then that presumption doesn't apply anymore. So he had to some explaining to do, so to say, and the judge
Hmm.
didn't buy it.
Yeah, exactly. I see all the time with my clients that who are divorcing men who own their own businesses. The businesses have been doing great for many, many years, and as soon as they file for divorce, suddenly their businesses are doing terribly. Suddenly the businesses are failing.
Of course, the
Yeah, or
market
or
changed.
yes, right, exactly. And that, I'm like, well, fortunately, it's really based on the last 3 to 5 years, not the current state of the business. But also, like, I call bullshit, really.
Yeah,
I call bullshit. I don't think that the business is really failing that badly all of a sudden. Very convenient.
exactly. And then we have to hire forensic accountants because then they're going to be the expert witnesses if the funds permit it. And then we go through the tax returns and see where the deductions are
Mhm.
actual, not actual deductions for the purposes of paying child support or spousal support.
Right.
All these travels and vacations and luxury car number three are not proper deductions.
That's right. That's right. So how do we deal with this, let's say, like support or child international custody? What again, like let's say one parent wants to relocate abroad, maybe to the country where they came from, maybe even the kids were born there. I don't know. Um, how how do the courts determine who can move where with children?
Excellent question. I am scheduled to be in trial end of the month because a parent, a mother, decided that she would like to relocate to Europe
Hmm.
and take the 9-year-old child with her. And they have been living for 10 years in California. So
Hmm.
the strategy in cases like this, depending who I represent, if I represent the mother, then I would get, if possible, sole legal physical custody first.
Yeah.
So then when the relocation request happens, there is a presumption not only that mother can relocate, but father now needs to prove the change in circumstances. So it creates a whole set of, it's called Lamouche case, L-A, and then the second word is M-U-S-G-A.
Hmm.
It's a Supreme Court case in California that outlined factors, and I have a whole video on my YouTube channel about all the factors. I'm not going to bore you with that.
Okay.
But in that case, the court went factor by factor. What's in the best interest of the child? How old is the child? What is the connection with the community of the child? What is the distance? If it's long distance, then of course it speaks against the relocation.
Sure.
Can father who stays here, usually it's the mother who moves. I rarely seen cases of relocation where father wants to take the children. So can father take care of the child if mother relocates? Because the presumption is the parent who wants to relocate is going to relocate. The court cannot say you have to stay because
Sure.
it's
Right.
constitutional right to travel and to move around. So then can the staying parent take care of the children? How's
100% of
his
the time.
how's
100%.
his schedule, right?
Yeah. Right.
100% of the time. And then what would be the reverse schedule? So there's a lot of strategy goes into it. We'll look into domestic violence restraining order factors. Has there been abuse from either side? What about co-parenting? Has there been alienation from either parent?
Hmm.
Depending who I represent,
Sure.
speaks towards the. And then in cases where there are funds, I suggest to hire custody evaluator.
Hmm.
Custody evaluator is usually a psychologist who will take hours and hours to interview everyone involved: parents, school teachers, therapists, friends, family members, and then go through the factors and provide an extensive report to the court and to the parties about the conclusion and opinion about the relocation.
Hmm. Yeah, I mean, it's a lot to get, I think to get relocation with children, even across state lines, right? If it's a certain distance, it takes a lot to prove that it's sort of worth or to get permission to take your child away from the other parent.
I used to tell my clients or potential clients or whoever I was talking about the relocation that relocation, I would say, number one and the most difficult thing to go through, especially to prove that relocation is in the best interest of the child.
Mhm.
Until I had that one case where the judge ordered, so there was a case where my client filed for so mother relocated a couple hours away,
Okay.
and father stayed in San Francisco, and they enrolled them into private school, and mother refused to sign the scholarship paperwork, which gave both children $90,000 scholarship for the schools.
Oh my
And
God.
she moved to out of 40 miles away, which is an hour, so it would be impossible to have the children drive in and out. And so we filed an ex parte and got a long cause hearing, a trial on the issue whether the court can sign the relocation, sorry, not the relocation, but the school
The
documents,
scholarship papers.
application, the
Yeah.
scholarship paperwork.
Yeah.
And so in her response paperwork, she said father exercised coercive control
Hmm.
by not allowing her to go to church and among other things. But that was the most. And when I asked her on the stand, I'm like, what would be if you said no to him when he said on Sunday, don't go to church? Well, I could have said no to him, but I didn't want to have a conversation about it. And so the judge ordered that after this trial, the judge ordered that mother can relocate. She went through all Lamouche factors. She gave her sole legal and physical custody over that coercive control testimony. And then she said that mother can enroll children in whatever school she wants.
Mm.
So I thought relocation is really, really hard until that case. Like,
Right.
what
Well,
happened? Where did this
yeah.
come from? It's like,
Well,
how can you?
because coercive control is codified as a form of domestic abuse in the state of California, If it, sure, she could have said no, but what were the ramifications? So if she proved that, like, I could have said no, I could have said the word no, but it would have I knew that there was a rules-based, dynamic whereby if I went against him, I was going to be punished for it. Then I guess that was the outcome. But
Yeah, exactly. But
yeah,
it was part of the. I understand the coercive control piece, but how it was tied to relocation, sole custody in the background,
Mhm.
that's the part I was expecting to be more complex.
Right, because he just said, okay, that's it. Now he basically, your client lost custody entirely.
Like retroactively, right? She
Uh-huh.
relocated, and then retroactively, the judge said, okay, that was fine because
Right,
of all these
right.
factors.
Uh-huh.
So
And you can
just
also take your children.
correct. So
Yeah.
what I noticed is that the 3044 presumption, which is when abuse happens within the last 5 years against the spouse or the children, the victim gets sole legal physical custody, can be rebutted. So that presumption doesn't mean that a client or a victim has to file for domestic violence restraining order because she didn't. So
Right,
it can be
right.
done in any custody proceedings.
Mm.
So some people say, well, I don't want to go through domestic violence restraining order trial. I just want sole custody. And that's the way that 3044 presumption works. It can
Mm.
be done just by responding to something else related to custody.
Yeah. I mean, it's so complicated because there are very valid reasons I think that women don't file restraining orders because they can, be punitive and there can be blowback and it can be really dangerous even to do it, right?
The other side could lose a job and not pay child support because they have a CLETS restraining order on their record. So they would like
Exactly.
sole custody, but they also would like to get child support. And by filing the domestic violence restraining order and asking for sole custody could mean
Losing a job. I have a client right now whose spouse is, I mean, an absolute terrifying abuser, but he also works in the correctional system. So if she were to file a restraining order, he would lose his job, and then he would retaliate because of that, like very violently, right? So we have to kind of work through this system and like what all these little,
yes. And I'm
yeah,
saying this
yeah.
because I have been practicing for over a decade and I talk to different lawyers and like, actually, did you know you can file a responsive declaration and ask for sole custody because of abuse, because of 3044, the code section? I even had to do briefing with the judge explaining that it's possible.
Oh wow, that's really
Because
interesting. I haven't heard
because
about this.
yeah,
3044, is that that's California code?
California Family Code, yes.
And what does it say? It says that
It says that if abuse happened, and I'm paraphrasing, if abuse happened within the last 5 years, then the victim of abuse gets sole legal physical custody unless the presumption is rebutted. And the presumption of sole custody can be rebutted if the other side says, I redeemed myself, I have done whatever the court said I need to do, better intervention program or whatever. But the point of that code section is that in any custody proceeding, sole custody can be requested, not just in domestic violence restraining order proceeding,
right. Okay.
as
And
long as
then is
abuse
that
happened in the
all
last 5 years.
and the and that's only for child abuse or also for spousal abuse?
It says abuse. Let me double check. I think it says both. Abuse 30. Finding by the court that a party seeking custody or child has perpetrated domestic violence within the previous 5 years against the other party
Oh,
seeking
interesting.
custody of the child
Okay.
or against the child. So both, like I
And
said.
that's in California. And that's something that, we fight all the time as advocates because a lot of the time the court will say, well, they didn't abuse the children. So just because they abused you, that's a relationship problem, which abuse is not a relationship problem. But they will say, well, that's a relationship problem. He didn't abuse the children, so that's fine. So this is actually really interesting to know in California that this statute exists. Thank you for,
Exactly. It's
yeah.
or. And
Mm,
then if the children witnessed it, they can be also part of this code section.
Yes, as they should, right? As it should. They
Exactly.
should not have to do that. But yeah, that's very interesting. Um, so, uh, what other cases or like interesting things have you worked on that you think would be sort of, just anecdotally interesting to our audience? What are some other things that have come up in your caseload?
Sometimes I feel so devastated how people talk to each other over text,
Mm,
and everything comes into evidence.
yeah.
So at times I have this trial where we have a package of text messages where she wrote a letter to him about what he did wrong,
Yeah.
including abuse. And then he responds to that. And so my advice, not advice, but my suggestion is to communicate in a way that the world can see it, and you're not going to be you're going to be proud of how you communicate.
That's right. That's right.
And it's going to be very short, sweet, no adjectives, no insults, because everything can be used against the person who is writing it.
Yep.
And electronic production is very common. So every single post, a client told me she had a case. So I was representing her in a divorce case, and she said she lost a case where she was claiming she was disabled because on her social media she posted how she was cooking and gardening and things like that, where she said in court that she couldn't walk, but then she would post something else.
Right.
And so now there are softwares that we can buy that can analyze every post that was deleted.
Oh, wow. Wow.
So, and this Electronic Production Act, or whenever I talk to a client, potential client who hires me, then I remind them that they're not allowed to delete anything. And so the other side is not allowed to delete anything on social media, emails, text messages, changing phones. How many times do we send the subpoena and say, produce all the text messages between you and X about the child? They're
Mm-hmm.
like, oh, my phone, I lost my phone, or I changed my phone. They have a duty to preserve evidence.
Mm.
So it can be sanctionable not only against the other client, the other side, but against the attorney for not advising them to preserve evidence.
Oh, that's really interesting. Yep. And I think the main thing is that I always tell my clients, like, if you don't want a judge to read it, don't put it in writing. If
Yeah,
you all of your communication should be filtered through the lens of I'm writing like dear judge and like CCing my ex, right?
yeah.
So you want to be speak communicating in a way that you can be on the stand and stand behind it.
Many, many years ago, I remember the easiest DV case I won was I was not seasoned attorney yet back then. So the other side wrote a nasty text message, just one, right?
Mhm.
And so the judge is like, how many days of trial do you need and how many hours and who are your witnesses? It's like, I'm looking at the judge. Your Honor, he wrote this text. He can grant the restraining order right now. We don't need a
We don't
trial.
need a trial.
And she looked at me and she said, Mr. X, did you write this? He's like, yeah, I did. Okay, restraining order granted.
There you go. Yeah. Well, I don't think we need a trial for this, Your Honor.
Yeah, we
You.
don't.
Yeah,
Yeah.
exactly, exactly. Well, Diana, this has been very fun and informative. Where can people find you? And I know you mentioned you have a YouTube channel, so where can everybody find you and learn more from you?
I created the easiest hashtag that anyone can think of, divorce like a boss. If you type it in Google, you will find everything. You will find the Instagram, YouTube page, and from there you can see my website and phone number and how to schedule a meeting. It's all there. And I sell my book on Amazon, also called Divorce Like a Boss, in
Awesome.
4 formats.
Okay, great. Good. So that's divorce like a boss, everybody. You got that? Diana, it was really wonderful. Thank you so much for being here. This has been a great conversation.
Thank you.